Good afternoon, everyone. My name is JC Weslowski, Experience and Communications Manager here at the Chamber. If we have not met already, ordinarily it's Mark McGill, our Director of Member Relations, on this call being the host, but he is unavailable at a ribbon cutting today. So here I am. First things first, I just want to take a moment to thank SIM Financial Advisors, great partners of this series, the Solutions for Success series for the second year in a row. I'm just going to go ahead and take it over and let Evan Stark, financial advisor and partner at SIM Financial Advisors, say a few words. So here you go, Evan. Thank you.
Thank you, JC. Yeah, we love partnering with the Chamber, especially when it comes to educational type stuff. And this has been a fun series, getting to know other businesses in our community, getting to learn things from folks who we might partner with at some point if we don't already. And it's really fun to get to glean sort of uh, all these different topics and things that people in our community are doing. I always say about this community, if you take care of this community, it takes care of you. And partnering with the Chamber has been a fun part of that. SIM Financial Advisors, like I said, happy to partner with the Chamber on this and sponsor this series. We're an independent financial advisory firm based out of Winona Lake originally. We now have 6 offices throughout the Midwest and clients in almost every state and a few other countries. We manage around $5 billion on a discretionary basis. We're what's called fee-only fiduciaries. There's a lot of questions you can ask a financial advisor as you're kind of shopping around. I'll pick a couple of my favorites. The right now, especially, who owns your firm? With as much acquisition and private equity purchasing that has happened, that's a good question to ask. Are you a fiduciary? How do you get paid? And how many clients do you specifically manage? Those are really good questions if you're in the market for a financial advisor to ask. If you ever have more questions, we're here. We're a part of this community, part of the Chamber, easy to get a hold of. Reach out to me at SIM. And yeah, we're happy to be here and look forward to learning more from Benjamin as he talks about this sort of a sensitive and pertinent topic.
Thank you so much, Evan. And just thank you again to SIM Financial Advisors for sponsoring the Solutions for Success series. Now we will go ahead and get into our topic, Solutions for Success, Navigating Free Speech and Social Media at Work. So today we have Benjamin or Ben Perry, Associate Attorney at Barnes and Thornburg South Bend office. He's going to walk us through the current landscape of employee rights, employer responsibilities, and best practices for social media use and free speech in the workplace. So Ben here shortly will share his screen and start presenting. If you have any questions throughout the presentation, go ahead and leave them in the chat. Depending on the amount of questions, we will either answer them throughout or we may wait until the end. So yeah, just leave them in the chat and then we will be sure to address them at some point. So now I'm going to go ahead and turn it over to Ben. Thank you.
Thanks, JC. Good morning, everyone. I get the absolute privilege to talk about the super controversial topic of free speech, uh, which is great. Uh, I've got a presentation that I'm going to show, but I know that this was a topic that was interesting a lot of members of the chamber. So if there are questions and you are not getting the answers you are looking for as I'm going through things, please do put the questions in the chat. I'm also fine if you want to turn on your microphone and interrupt me and ask questions. However, it works best for you to make sure you're getting the information you need. So, free speech in the workplace. First, a little bit about myself, just because it's a presentation and that's what we're required to do. I'm a South Bend native. I work all across the country, though. I worked in human resources for a long time before I went to law school. So I have a lot of on the ground experience dealing with a lot of the issues that I'm going to be talking about today. I had a For that, I had a film degree, or I still have a film degree. I also have a now 5-year-old daughter. This is out of date, and a collection of over 100 board games. I also finished Bourbon Trail and opened a lot of bars in Louisville. So I'm more than just a lawyer. I'm an actual real life human being. Um, some agenda topics for today. First, I want to talk a little bit about free speech generally. I want to talk about the First Amendment, talk about what it does do, what it doesn't do, what its role in the workplace is. I want to give some examples of controversial speech, maybe share some horror stories from my past, some horror stories from your past, if you're willing to share, as well as some real life examples of how these things have played out in workplaces across the country. I'll address some of the practical concerns that we see from these kinds of conversations and topics being said either in the workplace or online on social media by your employees. And I want to talk about some of the legal concerns that arise from those practical concerns as well as what the best practices are going to be to address these issues, as well as what policies might look like. And at the end, we haven't had any questions addressed throughout. I'll leave some time for that. So, first things first, the First Amendment and its application. Everybody is familiar in concept with the First Amendment, but here is its full text for those of you that haven't been in a social studies class in a long time. And it's that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. In plain language, these are your freedoms of speech, your freedom of religion, the freedom of the press, the freedom of petition, and the freedom of assembly. And practically, what this means is that it's protecting those fundamental rights from government. And the key word there is the government interference. This is applicable to public employers, but there is no direct application to private employers. I'm curious if we have any public employers on the call today. And if we do, I'd love it if you could just throw something in the chat so that I can keep track of what's relevant to what group of people. And by public employers, I usually am referring to government employers, schools, government officials, etc. But this can also get brought in for those of you that have contracts with the government, because there are protections that kind of filter down through those contracts as well. So for our public employers, not everything is protected. There's this test that the courts have developed called the Pickery test, which balances the employee's right to speak on matters of public concern against government's need to maintain workplace efficiency and public trust. And this doesn't sound like a straightforward test because it's not a straightforward test. Pretty much each phrase in that sentence that I just read has a lot of complexity and nuance in it. As you have to ask questions such as, is the matter that the employee is talking about a matter of public concern? And what is the need to maintain the workplace efficiency? And how do you balance those? These are all very complex tests. So everything that I talk about today, not just this, is not direct legal advice. This is all knowledge-based stuff. But everything we're talking about today is so incredibly fact-specific that it's hard to provide a one-size-fits-all answer to each situation. For our private employers, there is no direct application of the First Amendment. You have a much broader ability to regulate speech in the private workplace. So some of the main reasons you want to regulate speech, and some of the main reasons we see companies regulate speech, are setting expectations for professionalism, trying to avoid disruptive conduct, and try to enforce policies consistently. So the overlap between your free speech impairments that you're putting in place at the workplace, your regulations over social media posts, your what people can talk about at work policies, those have a lot of overlap with your EEOC policies, your harassment and discrimination policies, etc. It's also important to note, though, that there are some states that have broader laws that dictate how much an employer, even in the private sector, can regulate speech, how much they can restrict people from saying things either in the workplace or online. Some of the main states are usual offenders in my line of work. The Californias, New York, Colorado, Louisiana's and Minnesota's of the world, where more progressive laws are in place. That's not ever going to be Indiana, so there is no broader protections we need to be aware of in our community here. What are some of the types of controversial speech we see occur in the workplace? Broadly speaking, these fall into two buckets. There's speech at work and speech outside of work, and that's our big italicized scary social media word that everybody is concerned about and where most of these problems seem to be arising lately. So at work, though, is our water cooler talk concern. We see political debates breaking out in the break room about elections, immigration, gun rights, social movement, you name it. People have opinions now more than ever. And in our political and social climate nowadays, these are becoming more hostile conversations more quickly, more sensitive conversations more quickly. We also see this in the form of more broadly speaking definition of public speech or free speech. Employees wearing hat pinned clothing with political slogans or aligning themselves with social movements or political parties, etc. Those are also in a broader world, in the public sector, for example, those can constitute free speech. Similarly, those might be things that we try to regulate in the workplace. We also can see religious expression that crosses over into proselytizing or makes coworkers uncomfortable. There are things where you are trying to convince people to come to church with you, or even taking moments for yourself to do your own religious activities. And how do we juggle that with maintaining a comfortable and safe workplace for everybody else? And just in general, we can see heated discussions, even though not directly related to a specific topic, that can distract employees. You see your inner office disputes can result in heated discussions, or even in front of customers that can impact professionalism or the company's reputation. Your online speech on social media can take even broader things. Everything that I just talked about can occur online as well. But some examples could be an employee posting a controversial opinion online and even just listing your company in their profile. Say on Facebook, I list myself as employed by Barnes and Thornburg and I post a controversial opinion. Is that reflecting me or is it now reflecting the company? Or if I use offensive language or symbols and then those go viral, say I make a post that becomes popular on TikTok and it either offensive or even just controversial, and I'm wearing my work uniform. Is that, once more, is that affecting me or is that portraying the company's brand? And we can also see these things happen where an employee uses social media to vent about a frustrating day at work and they're criticizing either management or the workplace generally. And can that be regulated? So, some participation time. If you guys don't mind dropping in some examples of types of real or fake controversial statements that you can think of either your employees making or other employees making. And just to get the ball rolling and put everyone at ease, I will say some of the most controversial ones out loud, the quiet topics out loud. Things like religious statements, like only God can save you. Is that okay to be posting or saying in the workplace? Or saying voting Republican is a vote against the United States. Or the opposite, let's go Brandon. Or vote Trump. Or vote Biden. Or vote literally any name you can think of and you will probably offend somebody. Or even just complaining about work, saying my boss, insert your favorite explicative, sucks. Seeing no participation, we'll just slide forward and we can revisit this later if need be. but some real world examples of terminations that have taken place in workplaces around the country. So all of these have resulted in termination. And I want to use these as examples of things where either people have uh, been able to support the decision to terminate the person, or situations that will highlight what we're going to talk about momentarily, which is things where it backfires and you're not able to support that termination. So, for example, in Georgia, a high school teacher, and this would be a public employee in this situation, was terminated after writing a racial slur on a whiteboard. And that one was able to be upheld because it was so offensive that it counterbalanced the need, the perceived need for public speech, even by a public employee. We also saw an employee that got terminated after posting a negative comment about a supervisor online. That hypothetical that I just stated, where a bad day happened and I was complaining about my boss on Twitter or on Facebook, because that's my safe place to vent. Uh, Employee was terminated, but the National Labor Relations Board intervened and said that this was a violation of the National Labor Relations Act, so the ability to unionize. And we'll talk about that in just a bit more. And I'm going to acknowledge all the examples that I've seen come in, and we'll pop back to those in a minute. So thank you. Keep them coming. In Texas, a nurse posted about a patient's measles diagnosis. She didn't disclose the patient's name. She didn't disclose even where it came, where the patient was. She just said there was a measles diagnosis in my hospital. And she was terminated for that. And it was found that that violated HIPAA, which is our Patient Privacy Act law. And it violated HIPAA, even though it didn't state who the patient was. Just merely that sharing that there was this diagnosis was enough to violate HIPAA, and so that termination was improper. Gate agents were terminated after mocking a passenger. That one was able to be upheld. In Tulsa, a police officer, again a public employee, was terminated after posting inappropriate and unprofessional content on Facebook. And again, we had to go through that Pickering test and weigh whether or not the ability to make those posts outweighed any impact on the workplace specifically. And that one, it was determined that the officer was not able to serve the community impartially. Waitresses have been fired after leaving racist comments on bills. HR managers have been fired after posting screenshots of job applicants' resumes while making mocking comments. And a Citibank employee was terminated after posting anti-Semitic remarks on Facebook, and the company took a much broader stance as a private employer, stating that we condemn anti-Semitism and all hate speech, do not tolerate it in our bank. So you can see kind of the range of things, and these are all worst-case scenarios. So some of the examples that I'm seeing in our chat is encountering a salesperson who has a practice of starting his team meetings with a Christian prayer. Not illegal in a private workplace, but if it's making other employees uncomfortable, then we have a potential issue that may or may not need to be addressed. A post including certain firearms that was sponsored by companies was one that we encountered. Again, nothing illegal about that in the private employer setting, but what is the effect on the company? And we're going to get that recurring as we move through some of the practical and legal issues. What is the practical concern of these posts? And posting on social media, this training day is terrible, such a waste of time, such an effing joke. They are posting about their employees during paid employee time. What are the limitations from an HR aspect? I'll come back to that as we go through things. But all of these are some of the examples that we're seeing out in the real world. We also see this in the news. So last year, there was a rash of terminations as a result of social media posts related to the Donald Trump assassination attempt. And we see that now with the Charlie Kirk assassination. A lot of social media posts and a lot of terminations coming, regardless of the side that somebody is posting on, either supporting one side or the other. Terminations happen and it gets in the news. But as I said, isn't any of that legal? No. None of that is illegal to do explicitly on its own as a private employer. It's usually not the post itself that's the problem. It's how other employees or your customers are reacting to the post. And that leads us into what the actual practical on the ground concerns are with these free speech concerns. So, some of the practical concerns that we see that come as a result of controversial or hostile posts are an impact on workplace morale, team dynamic. These kind of comments can divide staff. They can create hostility among each other. They can erode trust. Really, what it comes down to is it creates a grown-up version of high school where cliques form, where there are bullies that can rise up, and certain employees become outcasts in the workplace. None of which is great for the business side of running your business. Another concern is the obvious customer relations, public reputation. Customer facing roles can have that same effect that I just talked about internally, externally. So a salesperson making social media posts could be seen by a client. That's your high level version, but it can go all the way down to hypotheticals that I discussed of comments while prominently listing your company in their profile. And even a single viral screenshot of an employee's social media post, they me making a claim while wearing work uniform, can cause real reputational damage to the company. Another practical concern is that these comments can cross over into legitimate harassment and discrimination risk for the business. Speech can very easily cross a line from a political topic or a social topic to actually illegal conversations and statements where harassment occurs, discrimination occurs, or a workplace starts becoming a hostile work environment for a certain group or subset of individuals. Some of the examples that we see most often lately are comments on immigration policies can quickly become perceived as racist. And I'll give you a direct example is that at my workplace at Barnes and Thornburg, we're highly encouraged to not make comments or presentations regarding immigration. One, because there's concerns that it could be perceived in this way, and two, because there's practical concerns of fallout with our government contacts, our government contracts, just because of the political nature of the world that we live in. Another example is gender adjacent discussions can quickly become seen as discriminatory. I've seen claims where people just talking about pregnancies have been taken as sexual discrimination in some way. We can see religious discussions that make people feel uncomfortable to the point that the workplace feels hostile with them. So the example that Kyle shared in the chat of a salesperson starting his team meetings with a Christian prayer. Sure, that could be inoffensive, but if there is somebody that does find that offensive, and it is occurring so regularly that they are feeling uncomfortable at the workplace, that is a potential claim for a hostile workplace for religious discrimination. So once speech impacts a protected class in one of these ways, then you may be legally required to intervene, to step in and address the concerns, even though comments on their own are not a problem. It is, again, what are the effects of the comment? There's also operational disruption that results in the flow from all of this. So if we have this high school mentality and cliques forming, we're going to distract employees, we're going to impact productivity, we're going to create tension and reduce efficiency, collaboration is going to go down the drain. And ultimately, if these things do rise to the form of harassment and discrimination, and even if they don't, frankly, just addressing it and monitoring it requires HR resources to manage throughout the day. Spreading outside of just the practical concerns, though, there are legal concerns. The biggest one, and if there's one thing I want everybody to take away from this, is that consistent enforcement, whatever the policy is that you put in place, is crucial. Whatever you do, whatever stance the company takes, you must do consistently. This is a really delicate challenge because you can't create the perception that one side is being favored over the other. So just because one side, one opinion, one belief is more popular does not mean it's right. I'm going to use Christianity as the predominant religion in the United States. Leading your sales meetings with a Christian prayer is probably not the most offensive thing. Christmas, historically Christian holiday, is a prominent part of our society. Christians are well accepted by everybody in society, generally speaking. Everything that I'm saying is generalization. But just because it is the most popular does not mean that it's any more right, legally speaking, than any of the other ones, any of the other religions. So there is a distinct possibility that somebody would be offended, or there's the more scary possibility in my world of, let's say, some other team leader begins their sales meeting with a religious ceremony of a different religion, and the company stops one of those but not the other. Then we are creating a very clear cut, very problematic discrimination claim for one set of those people. So favoring one side, even unintentionally, can create the bias and unfair treatment that is the crux of the legal concerns here. In short, have to be Switzerland. All of this is stemming from the anti-harassment and anti-discrimination law. You've got Title VII and the full alphabet soup, which is the ADA, ADEA, PWFA. All of these require protections for different subsets and groups of population, protected classes. And it requires intervention if speech ever rises to the point of becoming discrimination, harassment, or creating a hostile work environment. And that cannot be ignored, even if in a public environment, for example, even if a teacher, the teacher that we used as an example earlier, even if he claimed that that was a political statement, writing a racial slur on a whiteboard, because somebody could say that. There are cases out there where people have defended very discriminatory belief as political or religious belief. But you cannot ignore that if the outcome, and again, it is the practical effect of the speech as opposed to the speech itself, cannot ignore it just because somebody gives you the excuse or the justification that this is their political belief, their religious belief, their whatever belief. Defamation, confidentiality, trade, I can't even read it. It's so confidential. But statements that can cause defamation, confidentiality, or breach trade secrets, these are statements that can always be restricted. So we started off with statements that we can't restrict, and now we're moving into things that are much more clear, yes, we can restrict. So these are not required. There's no legal obligation on their own that certain information can't be shared, but you can set parameters and set policies that say you cannot breach confidentiality, you cannot share trade secrets. My recommendation on this front is to make sure that you are governing the protection through independent employment agreements, confidentiality agreements. But there are some very solid no-nos as well. In addition to the retaliation and discrimination concerns, there is retaliation and whistleblower protection. So employees that speak up about illegal activity or workplace safety, employees that make statements about OSHA concerns, for example, or make statements that the company is performing some illegal activity. A lot of these laws have their own whistleblower protection in them, baked into that. And if you fire somebody for making those kind of statements, then you run afoul of that fact. You run afoul of OSHA or any of the Whistleblower Protection Act and have a separate lawsuit on it. Similarly, we alluded to this earlier, the NLRA, the National Labor Relations Act, this is your unionization, allows for protected concerted activity. What this means is any employee talking with other employees about wages, schedules, supervisors, safety issues, or other terms and conditions of employment. And this has been taken very broadly. in the historic context of it's not just like John is talking to Sally about how much they make and comparing wages. It could be John is posting on Facebook about how his boss was rude to him today, and that was inappropriate. And that could, on its own, be determined to be protected concerted activity. So this is the example that we talked about earlier, where somebody was complaining about work on social media. Heather in the comments shared that posting on social media this training day is terrible, such a waste of time, such an effing joke. That could be determined to be protected concerted activity. And it is a question then of balancing whether or not the risk of potentially stemming unionization effort and running afoul of the NLRA is worth the potential reputational harm that those comments are making. And that is, again, a very case by case, hard to determine basis. But the risk with the NLRA is that if something like this happens, an employee could go to the NLRB, the National Labor Relations Board, and file a complaint. We also see if there are policies in place that prohibit certain types of discussion, particularly discussion of wages, which is a common mistake that I see in handbooks when I'm reviewing handbooks. The NLRB might on their own come in and say this handbook is in violation of the NLRA and issue fines to the company or instruct the company to rework their handbook. Enforcement of the NLRA will vary by administration. Historically, we've seen very broad coverage, including for social media posts. Right now, we see less broad restrictions. So generally, again, huge broad generalizations. Under Republican administrations, we see less enforcement. Under Democratic administrations, we see more enforcement. It comes in waves, and it's just something you have to be aware of when monitoring all of these types of topics. And there's a huge gray area in governing speech, which is off-duty conduct. So any conduct unrelated to work. So if I post something on my social media, not while I'm at work, while I'm at home, while I'm on vacation, but can the company discipline me for for the content that I post? Some states have protections. Again, we're in Indiana. We're not going to have any further protections for that. But the question the same thing that I've been saying consistently, it should not be about what the content is specifically, but what is the outcome of that content being posted? Did the employee posting their statement in their free time have some negative impact on the company? The answer to that is yes. Then you might have an appropriate reason to discipline them. But if the answer is no, then my recommendation would be to let it lie. So what do these policies look like? Well, your best defense is a good offense. And by a good offense, I mean your best defense is a good policy. Effective policies are going to ensure fairness, they're going to ensure clarity, and they're going to maintain professional standards. It is the behavior, not the beliefs, that you want to focus on in these policies. You should focus on the behavior issues that arise from the speech as opposed to the speech itself. A good policy would not say you are prohibited from talking about politics. It would instead say you are prohibited from talking about things that will cause disruption in the workplace. You're prohibited from making statements that result in harassment, statements that breach confidentiality, or you must maintain professional conduct in the workplace. Now, professionalism is itself a gray question of what is professional? What does that mean? That's something you might need to dig into in your policy as you're working through these problems and see what do you want professional work look like in your work. Remember, though, whatever the case is, these must be applied uniformly. They must be content neutral. You need to ban if you do choose to go a topic route, must ban all of something, not just some of it. You can't ban just you couldn't, for example, ban uh, all religious conversations other than Christian conversations. So I do see one question in the chat right now. If a policy is in place beforehand, may you discriminate? For example, we are a Christian company or the like. I would say no. You cannot rely on the fact that like this is a Christian workplace to then discriminate. There are certain exceptions for religious organizations, but whether or not your company qualifies as a religious organization is itself a complex question that we're not able to jump into today necessarily. But if for example, you just have a reputation of being a Christian organization, then uh, then like there's probably the expectation in the workplace that things are a certain way, but that does not eliminate the possibility of, say, hiring a Muslim individual or a Jewish individual or a you choose individual and them coming in and feeling discriminated against. And if you are not in one of these carve outs for a specific exception to these laws, then you are risking lawsuit still. Regardless, and this is good in general, you should set clear expectations, how they should present personal views versus professional views online. When does their online conduct affect companies? Spelling these things out for employees so that there are clear guidelines is crucial because it's going to help you on the back end as you figure out how to address the online situation. You should also comply with the NLRA requirements. So here's some of the big ones that I see in this world. You should avoid broad restrictions that could impact protected concerted activity. Things like do not make negative comments about the company. That on its own is going to risk running afoul of the NLRA. Instead, reframing it as you must maintain a professional attitude, and then defining what professional attitude looks like. Do not discuss workplace problems publicly. Again, that could run afoul of the protected concerted activities with all of the examples that I've already talked about. You must always be respectful to your supervisor. On its own, sounds great, right? But if it's taken as and enforced as you can't talk bad about your supervisor, the F my boss kind of situation online, those could be determined to be protected concerted activity. So again, it comes back to you want to try to dictate the conduct and the atmosphere of the workplace. And I know that this is a complex, hard thing, and I'm dealing in gray areas. So I do have some example policies for you to look at as well coming up. Bonus one, do not discuss your compensation with your coworkers. That one will always get you in trouble. Finally, you should use policy as a tool to promote respectful, inclusive environments, but it's also an opportunity to create the atmosphere you want to have in the workplace. It's going to go hand in hand with your discrimination and harassment policies, but it should be helpful to you in supporting uniform application as opposed to an obstacle. Wherever possible, you should resolve the questions that we're asking now up front as to what is the stuff that you are concerned about happening. How can you have that phrased in a way to properly address it? Some best practices. So here's some sample policy language, and this will all be available to everybody afterwards as well. So for your anti-harassment professional conduct policy, all employees are expected to maintain respectful and professional communication. Speech or behavior that targets or demeans individuals based on legally protected characteristics is prohibited. Short, simple. You can expand on that to include examples, which I always recommend in handbooks and policies. You can spell out exactly what this looks like in the workplace. You could do any number of things with this, but this is the kind of neutral language that we're looking for in these policies. Civility policies can be, for example, employees are encouraged to share ideas and opinions respectfully. Conduct that disrupts business operations, undermines teamwork, or damages working relationships may result in corrective action. This is a good example of focusing on the conduct, the effect of the communication, as opposed to getting caught up on what the content of the speech is. Political activity and expression policy. Employees may not display or distribute political or ideological messages while on duty or in customer-facing roles. This policy applies neutrally to all viewpoints. This is a good example of explicitly spelling out that the company is going to be neutral in its enforcement. It's not going to be prohibiting just MAGA stuff, for example. It's prohibiting all political stuff. Social media policy, and this is a very short one. I frequently see social media policies becoming long, multi-page documents on their own to try to address things, and that can be a good thing. It can be a bad thing. It just depends on what the company's stance is going to be with regard to social media, how strict it wants to enforce everything. So this example is employees are responsible for their online presence. Referencing the company or its business, employees must avoid disclosing confidential information, misrepresenting the company, or posting content that may harm the company's reputation. So two key things for social media policies that this example is doing is one, it's again focusing on the effect of the speech more than the speech itself. What are we trying to avoid? We're trying to avoid confidentiality breaches. We're trying to avoid misrepresentations, and we're trying to avoid reputational harm. The other thing it's doing is it's specifically spelling out that you are only regulating content that an employee is making on social media to the extent that it is reflecting or referencing the company or business, as opposed to just general statements in somebody's personal life. To be your off-duty conduct that we're concerned about. Some enforcement practices that you should be aware of. Training your supervisors is going to be key in this. And this is all of these enforcement pointers that I'm going to run through right now are really just best practices for all HR things. Training your supervisors as to what company is expecting of them is key because they're the ones that are going to be dealing with the employees on the day-to-day basis. Consistency is key, and a lot of the time we rely on managers and supervisors to make their best judgment call, but we're not providing them the tools to know how to be consistent from manager A to manager B. So you want to make sure that all of your supervisors, all of your trainers, all of your HR people are on the same page about everything. Second, and the biggest downfall that I see in my practice across the board, regardless of if it's a free speech issue, the wage and hour issue, discrimination claim, it's a wrongful termination claim, document, paper everything. Make sure there's a paper trail. If there's concerns about something that's being said, get a screenshot of it. Write down what happened. Make a note of it. That way, when a decision is made, you have everything documented to support why you made it and why, for example, somebody was terminated. You don't want to just have it said, we terminated this person because they made a post on social media. You want to spell out, we terminated this person because they made posts on social media that had significant reputational harm to the company, and we documented that over multiple times. Separate your personal viewpoints from enforcement. This comes back to just because one thing is popular, one thing is more common, does not mean it is uniform, does not mean it is right. You may have a certain belief, either politically, religiously, socially, whatever. That has to remain separate from your employment decision for your employees. Again, you have to be Switzerland here. You have to be neutral. Just because you disagree with somebody does not mean that they are wrong necessarily. Uh, they might be wrong. They might not be wrong. But disagreements on their own are not sufficient to potentially risk discrimination. Should also review policies annually with Employment Council. Things change constantly in the employment world, and the free speech issue is one that is uh, constantly in the news, especially lately, constantly moving. And while there might not be laws applicable to everything all the time, the best practices might change based on how the world is evolving. And a lot of the time, uh, employment council, people like me that are dealing with this every day and see it across the country, across the board, across lots of different companies, have a good sense of what is going on and what the best practices are for dealing with these situations. And most important, apply your rules neutrally, even when the underlying message is unpopular. So let's recap everything that we talked about. First, the First Amendment does not protect private employees. There's an asterisk here because government contracts can get involved, and there's always exceptions to exceptions to exceptions, why there is no one size fits all answer here. But for everybody here that is a private employer, there are no First Amendment protections. Your employees do not have a right to free speech from you because you are not the government. The concern comes not from speech itself, but instead from the downstream effects of that. Controversial speech, which brings us to point two, controversial speech matters because of its impact more than its content. There's an asterisk here because content can matter if it gets to the point of running afoul of certain laws, the NLRA, Title VII, etc. But speech can run afoul of those laws. Those are a big legal. Employers should regulate conduct as opposed to content through content neutral, objectively enforced policies. Policies are key. Policies are always going to be key. And downstream from that, documentation. And finally, social media is just making these issues more complicated than ever before, but also more important to address proactively. Your role as business leaders is not to control what people are thinking, but to make sure that a respectful, productive, and legally compliant workplace is available to everybody where employees can do their best work. I'm going to reserve the rest of our time for questions and answers. I'm going to go through the questions that I currently have in the chat. But if you have more questions, please dump them in the chat. I want to make sure that I'm covering everything that people are concerned about today. So Heather's question, which was related to the posting on training day that the training was a waste of time. What are our limitations from an HR aspect? Your limitations for that situation, for example, like the concern there is this content running afoul of the NLRA? Is there complaints about training sufficient that it's going to be considered protected concerted activity? That is a pretty fact-intensive question, but from a free speech standpoint, that is something that could be disciplinable. I would argue that the more proper course of action for discipline as you're documenting that is why is this person on their phone on social media when they should be working, as opposed to what is the content. So again, it's not about what the content is that the person is posting. Instead, it's about that they are wasting time, they are disrupting the workplace, they are not completing their assigned task. I tend to view the temperature of my leaders where I work. For example, one leader was facing some difficult personal challenges at the end of an email communication. The leader said they were thankful to God. I personally do not find this language offensive, thus I weigh carefully what I say in the workplace again, based on what leadership is saying. Not sure if this is right or wrong. I think that's fine. As I said at the beginning, this is every situation related to this topic is going to be case by case and very fact sensitive. In that situation, in theory, nobody was offended. Like it's the same as the situation that Kyle presented, where a team leader starting their meeting with prayer, with Christian prayer. In theory, nobody's offended. The problem comes when it becomes offensive. And if somebody came to you as a result of that email and said, hey, I did not appreciate that the team leader said they were thankful to God at the end of that email, then that's something that don't need to like fire anybody over, but that might be a situation where it's like, okay, thank you for bringing it to our attention, documented it, I'll talk to the person, etc. Some comments about Catholic or religion-based hospitals. Meetings generally begin with prayer, but termed reflection being sensitive to workers. Fine. Is it beneficial or good practice for employers to put a disclaimer in place, i.e., employees' opinions do not reflect or express the views of XYZ company? Yeah, that's great to have in your social media policy. It doesn't necessarily solve the outward-facing reputational problem because you can't go through and amend every employee's social media post with this employee's opinions do not reflect the opinions of company XYZ. But it is beneficial and a good practice to have that in your policy as well. Is there any more questions or topics that I did not cover that would be helpful for me to go over?
I think one question, and I know we're up against time, JC, sorry. Quick one, is the role pertinent in reviewing? So at my company, we consider, activity for most employees on their personal social media to be personal, unless, of course, the SEC, which governs our free speech quite closely. Unless the SEC has something to say about it, that's your personal speech. We don't care. However, if you represent the company in the community, if you're a partner, I own part of the company, if you're the CEO, essentially, does the role play into the potential damages or the perceived damages when somebody is speaking in a way that maybe the company doesn't agree with?
Undoubtedly, yes, of course, because again, it's not the content so much as it is the effect, and the effect of somebody's speech is going to be directly impacted by their role in the company. Like if the CEO of a company says something, that is going to be taken as much more reflective of the company's opinion as opposed to, you know, the lowest person on the totem pole. The example that comes to mind for that is like Chick-fil-A has very strong like beliefs by their CEO. And if their CEO said something, that reflects on Chick-fil-A as opposed to the fry cook at my local Chick-fil-A, who nobody cares what they're saying about, and nobody's going to take that as a direct statement from Chick-fil-A.
But yes, if there's no other questions, I'll go ahead and close everything out. Just want to make sure, do you have any more comments, Ben, before we close things
Um,
out?
if if you do have more questions, feel free to reach out. I'm always around. Uh, I love talking to people. I love doing these presentations. So feel free to reach out. Happy to meet up or just get on a phone call and answer any questions you have. So thank you so much for everybody's time today.
Perfect. Thank you so much, Ben. And thank you, Evan. And thank you to Sim Financial Advisors for sponsoring our Solutions for Success series that brings together everyone for these informational discussions. Today's was definitely a hit. I love seeing all the questions in the chat, getting everyone's questions answered. It's perfect. That's the purpose of these sessions. So thank you again, Ben, for the wonderful presentation. And yes, I hope everyone has a happy holidays. Thank you.
Thank you.